Okay, sir. We're good to go. Assalamu alaikum, everyone. Myself, Mohammad Amaz Zulfikar Mirza, currently serving as Secretary Media in LSC, and we welcome you all in today's webinar related to principles of arbitration. I would like to thank Mr. Nasir for joining us today. Brief introduction of Mr. Nasir is that he is the Vice Chair of Pakistan branch of Chartered Institute of Arbitration, and he is a legal expert in arbitration and principles. He's going to give a brief introduction of himself too. So let's go with the session. Sir Nasir, on to you now.
Thank you very much. Assalamu alaikum all. Thank you very much for all coming in on a Sunday and listening to this. I'll try and keep it a bit more interactive. So if you want to ask any questions throughout, please put it into the chat box and then I'll try and endeavor either answer it here now or at the end of this presentation. I'm trying to keep it to just about 45 minutes, which will allow us to have some Q&A at the end. And if you've got any specific questions, I'll leave my details as well. So thank you again, Law Students Council, Shahir, as well, to bring me on board to deliver this presentation. What is arbitration? What are the principles of arbitration? We'll try and cover it. Before that, I'll just give a bit of my introduction because it will allow you to think about how arbitration came into being. It's important to give a bit of my background. So I am still an engineer. However, I don't practice engineering as much because my role significantly moved into more commercial procurement and try to resolve disputes that are a natural progression in construction and infrastructure projects. Why do I say they are a natural progression? It goes back to the description and main element of what is a dispute. A dispute is a misunderstanding between two or more parties. I can't have a dispute with myself. I think that would be silly or crazy. So you need at least two people to have a dispute, to have a misunderstanding. It's important to explain that when we want to change something, one party may agree, it's resolved, but if they disagree, it can turn into a dispute. And hence my career progressed into more dispute resolution side of things, and where I started to practice mediation and arbitration. I wear several different hats, but most importantly, at the moment, I am a principal for HKA, which is the largest global consultancy on claims advisory and expert support in all forms of dispute resolution. My role very much revolves around construction, infrastructure, and transport. Last 5 years, I've spent majority of my time in port and rail infrastructure and some energy projects as well. So what is the Chartered Institute of Arbitrators and why Pakistan branch? I think throughout this presentation, you will see a theme why CIARB came into being and why we started it in Pakistan. So it's a charity. It's a global charity with a simple perspective to provide means of alternative dispute resolution, advice, training, guidance, a professional affiliation to practitioners so they can learn, grow, and develop the skills needed to provide a robust service to clients of all sorts. I've already explained general housekeeping in terms of Q&A and everything else. Throughout the next 40 minutes, we will try and explain the process of dispute resolution, and then we will come more into a specific aspect of arbitration. Why do I want to touch upon the process of dispute resolution? Because there are several different modes and means of trying to resolve a dispute. In any jurisdiction where litigation has been the norm, for example, Pakistan, I'll take you to court, I'll see you in court, and then you spend ages and years in court. Okay, let's not talk about the issues governing our court procedures. But when you are trying to find an alternative to litigation, an alternative process of dispute resolution, you call it ADR. That's as simple as that. It could be through our JIRGA system, it could be through arbitration, it could be through mediation, it could be through facilitation or an expert determination by somebody who's an expert in that field. The conundrum of dispute resolution is that there are two different spectrums. There is a formal procedure to dispute resolution, and then there is an informal procedure to dispute resolution. Now, choosing which ADR process to use for a given dispute will rely upon a detailed assessment by the parties, 1, 2, 3, or more, and their advisors. So it doesn't matter whether you are a party or you are the mediator or an arbitrator. The counsels, the advocates, the lawyers, solicitors, barristers involved in the procedure will help the parties to try and find out the best way forward to resolve the dispute. If we want to use technicalities in a litigation trial, we can take stay orders after stay orders or dates after dates. But if the vision, the purpose, the strategy is very much to try and find a resolution to the dispute, then of course we will try different ways where we can create a win-win solution. And please note that the important aspect here is to understand the dynamics of it. The more control you have on the process, the more you are forward looking, because it's not about what has been done to give you an answer or a decision on. It's all about how do we move forward. And that's where the difference between more litigative type procedures like in a court trial and more mediation type procedures come in, where you are looking at creating a consensual situation. Of course, the more mediative ADR process, the less binding it becomes. And then there is something in the middle as well, which is called MEDAB. MEDAB is a process that provides the parties least control in its final stage of arbitration, because the parties submit to an inflexible set of arbitration procedure and the decision of a neutral, but the certainty of outcome may be an important factor. So we need to think about what are the commercial reasons of a particular dispute, whether we want to have a resolution which is to our satisfaction. We need to understand the advantages and disadvantages of the dispute process. Now, it is the success of ADR that persuades parties and their lawyers to use it. So research and statistics generally show good rates of success and good levels of satisfaction. So the doubts over litigation are ever increasing. You already see there was a press release out by the Supreme Court of Pakistan on the founding of the ADR committee. So even the courts are looking at ADR more so. Questions have been asked that why are the courts looking at ADR procedure? I think with the backlog of 2.1 million cases, it becomes reasonable and it becomes natural for them to think about a procedure that helps the parties, because at the end of the day, access for justice and rule of law are the most important and pertinent elements. If we have any deficiency in access to justice or in the rule of law, then the society will crumble and we will not see a system that can operate sustainably. Now, going towards the elements of how dispute resolution process can work, what organizations are now opting for, and I actually have a clause from one of the power purchase agreement, because power is a big concept in Pakistan at the moment. Everybody talks about it with independent power plants, NEPRA, NTDC, the CPPAG. So I thought it would be good to get a clause, which is a standard clause from one of the contracts for multi-tier dispute resolution from one of the PPAs, power purchase agreement. So this is a standard clause found usually because it is in the standard contract that was developed by the World Bank. Now, many commercial agreements contain what may be called a dispute resolution clause or an ADR clause or a dispute resolution agreement or an ADR agreement. It is possible to include in the agreement a dispute resolution clause which simply makes provisions for litigation through the courts as the response to any dispute. It's like an escalation procedure. If you look at any standard form of construction contracts globally now being practiced, whether it's the NEC, FIDIC, ICC, or Swiss rules or German rules or even World Bank's standard procedures, you can see that they start with that the parties start with negotiation. They can then escalate to their senior leaders. If that doesn't work, they can go to mediation. If mediation then doesn't work, they can go to arbitration. I want you to focus some key points here, especially on the clause on the screen, because one of the element is the recommendation of the expert. So what is happening here is parties have started to do their negotiation. If their negotiations have failed, they've gone for an expert for determination. Okay. The recommendation of the expert is not binding unless it has been agreed between the parties or unless arbitration has not been commenced within 75 days of receipt. So there are some time bound procedures, there are some condition precedents involved. And then if the matter goes into arbitration, then you can read the arbitration has to be conducted in according with some rules. LCIA, that's London Court of International Arbitration, or under UNCITRAL rules, if for any reason, if it cannot be settled pursuant to the LCIA rules. So again, more references, more elements being produced into it. Let's look at how is arbitration being done in Pakistan, and then we move back into the international element again. So this was just a bit of an introduction for you to understand that there are various different dispute resolution procedures, and arbitration is just one of the various procedures involved in international commercial law, civil law perspective. So what is arbitration? So arbitration as the preferred method to dispute resolution in most commercial transactions, in most international trade transactions where multiple nationalities are involved, even in domestic elements. Why is that? Why is arbitration being, conducted? I mean, I'll come into why arbitrate element in a second, but just to provide you with a brief definition and introduction into why arbitration. So arbitration is an alternative to litigation as a means of resolving disputes. It is based on the parties' agreement. Agreement is very important unless there are some forms of arbitration that are implied by law. So if there are statutory provisions, they can be done. But unlike litigation, arbitration is still a consensual procedure where the parties decide how the procedure is conducted, what rules are followed, how they are followed, where the proceeding will happen, whether it will happen in London, Dubai, Lahore, Singapore, Hong Kong, wherever it goes into it. I'll give an example of the oil and gas, mining, and the energy sector. 60% of arbitrations globally happen in that sector. Construction related arbitration, energy related arbitration, oil and gas and mining related arbitration. It's very important to understand that that sector prefers arbitration for a very specific reason. And this is something that I want you guys to think about, that why is it that people feel that arbitration is better for them rather than litigation? Imagine if there are two parties involved, and I'll show you some case law in a couple of slides, where a company from England, where I am at the moment, is working in Lahore with a local company from Lahore. If the dispute are related, are focused more towards Pakistani element, and they go to the court, the party who's international making the investment and everything else has no control over those proceedings, and the results may have an unconscious biasness involved in it as well. Whereas if it goes to a neutral jurisdiction in an arbitration, then both parties have equal footing and equal opportunity. And that's one of the reasons why parties prefer that instead of technicalities in litigation, they would seek the advantage of an arbitration. Arbitration is an important element of dispute resolution because it was passed under the United Nations Convention, New York Convention in 1958. So if an award is made in Dubai for an arbitration of parties from Pakistan and England, it can be enforced in any UN convention entity or country. It can be enforced anywhere, which is one of the reasons why, and I'll keep a reference to the Rico Dick case because it's very important in Pakistan at the moment, that when Barrack Gold won the arbitration against Pakistan, they were ready to file enforcement in various different jurisdictions simultaneously to recover the award that was given to them, $6 billion US. That included Roosevelt Hotel in New York. That included the Pakistan Embassy in London because it's in Knightsbridge, quite an expensive property there. And across the board, they tried to enforce all of that until we know that a settlement has been agreed between the parties where Barrack will now invest in mining of gold and copper in Balochistan. So those elements are really important. Key thing here that I've highlighted in blue is the Section 2 of Pakistan Arbitration Act, which contains the definition of arbitration. Okay. Key features: it defines an arbitration agreement to be a written agreement to submit present or future differences to arbitration, whether an arbitrator is named or not. If you look at the Arbitration Act 1940, it provides for all those elements. Now, think about it in two different aspects. There is a law of arbitration, and then there is a rule or procedure of arbitration. And these are some of the differences. What you see here in blue is the law of arbitration. Whereas if I go back to the previous slide, LCIA are rules, UNCITRAL are rules. So law and rules are separate element in arbitration. Let's look at it in a bit more detail. But before we do that, some reference points. Why arbitrate? So as we've just looked at it, that when reviewing our options, it is important to consider, some of the key focal points. Okay, privacy and confidentiality, flexibility, choice, neutrality, as I mentioned, the binding nature of the award. As I said, the enforcement can be done anywhere with relative ease. The parties need to think about what degree of control as a participant you would like to have, who has the decision making authority for this dispute, what degree of decision making authority would you like the third party to have, whether you want a binding or non-binding award, and what are the power dynamics at play within the dispute. So structural features of the dispute we need to think about. Intended goal I mentioned because it's really important what you want to achieve through this arbitration, and some of these features allow us with ease to choose arbitration over other elements for various reasons. Now let's look at some of the case law, etc., that I mentioned because it's really important that we think about it. Okay, my guide on international arbitration has been Redfern and Hunter for a very, very long time. And if you ask any other practitioner, I mean, there are other books and things available as well, but I find this a very useful reference point for the procedure. A new version, I think, has just come out earlier this month. Um, then Ikramullah's Arbitration Law of Pakistan, which was published last year. Again, a very important aspect of arbitration and the development of arbitration law in Pakistan, where we called it judicial intervention, whether it's judicial supervision, how all of that element works, what are the different laws of arbitration, how they interact with each other. So I think that is a very important point of view, and I know there are some students of Ikramullah here in this presentation as well. So welcome to you all. And just to give you a reference point, we had a judicial perspectives on domestic and international arbitration in Pakistan conference in May of this year in Lahore. It was supposed to happen in Islamabad, but due to some logistical challenges, we had to move it to Lahore. And in this conference, we actually launched a Lahore pledge, which has resulted in some of the things that are happening in Pakistan now. For example, the ADR committee has been launched. There is a key focus on it. And then the Chartered Institute of Arbitrators, like it does for 150, 160 countries across the globe, is helping to promote ADR in any shape or form. Okay? And one of the things to do here today is a part and parcel of that. So arbitration in Pakistan, these are some very important case laws, because it's important that you consider reading these through. And I will talk about the Eckhart case, because Eckhart represents the suspicious prejudice by which the Pakistani legal community viewed international commercial arbitration. Now, it's not a new issue, and to be honest, this issue still persists. And I've had several discussions with various people where we are actually looking at, why are we going to international commercial arbitration for a case which can be done in the court, and then the sanctity of the court, the supervision of the court, all of those things are always discussed. One of the elements that is very prevalent in these discussion is the cost involved, together with the general perception of foreign arbitrators regularly ruling against Pakistani parties. Why is it? Why are they ruling against Pakistani parties? Have they got a bias or a prejudice against Pakistani parties? Now, this has led into this suspicion of international commercial arbitration, and the judgment in Eckhart has subsequently resulted in several conflicting judgments, which make it unclear when a Pakistani court intervention would result in the enforcement of a foreign arbitral agreement or not. Now, this is an old case, Eckhart. Since then, things have moved on. Similarly, I would like you to think about the separability issue, because one of the things in separability is very much so that if the main contract has been procured through bribery and corruption, but the arbitration agreement is separate from that. I'll talk a little bit more about the doctrine of separability, but for further reading, just put Sulamerica separability in your search engines and you will get a lot of text on it. Because one of the important thing is the law governing the arbitration clause shall be applied to determine whether it is null and void, inoperative, or incapable of being performed, regardless of what has happened in the entire contract. Because if disputes have arisen, these elements are separate, and that's why it's called the doctrine of separability. Some key further elements of arbitration in Pakistan, we need to look at public policy issue. Now, public policy is an important element, and it is reflected as one of the grounds for setting aside an arbitral award under New York Convention as well. And the model law has been developed accordingly. Now, model law and UNCITRAL Model law and UNCITRAL arbitration rules are two separate things, and I will explain it in a bit more detail in a second. But here, if you look at the Pakistan Wabda case versus Court Adu Power Station, here the courts defined public policy. Okay, that public policy would mean that no man can lawfully do that which has a tendency to be injurious to the public welfare. Public policy comprehends only the protection and promotion of public welfare. It is that principle under which the freedom to contract or private dealings is restricted by law for the good of the community. Therefore, it can be inferred that the meaning of public policy is the interest of persons other than the parties. So you're looking at a wider picture from that. So again, we can draw several different conclusions, several different elements from it. But then the key element that comes in it is how Pakistan Arbitration Act 1940 looks at it. Now, this presentation or lecture is not on the issues or drawbacks of Arbitration Act 1940, but very simply, all I would like to say is that New York Convention came in 1958. UNCITRAL model law rules were amended in 2006, which is what majority of the countries have adopted, who have signed up to the United Nations, who do international trade law and international investment. So if Pakistan needs to promote its international investment, it is important and imperative that we have laws governing those elements that support foreign investors and foreign investments and foreign trade to continue. Arbitration Act 1940 has been termed in various different jurisdictions as one of the factors that has affected Pakistan's ability to attract foreign investment. So we need to look at it into that perspective as well. Another element I want you to think about and look at is I'll come on to the current national laws of Pakistan, how they have moved on and changed. But before we enacted the Recognition and Enforcement of Arbitration Agreement and Foreign Arbitral Awards Act 2011, which is the REAAFA Act 2011, or the REACT. So we need to look at all of these elements so we can continue to see how the law has been developed. In SGS versus Pakistan, Pakistan filed a reference under Section 20 of the Pakistan Arbitration Act 1940 in a trial court in Pakistan, seeking the referral of the dispute to arbitration under the terms of the contract. Now, at the same time, SGS initiated an ICSID arbitration because it could do investment arbitration, because Pakistan and Switzerland had a bilateral investment treaty. So SGS is a Swiss company. So whether they had an arbitration agreement within their contract or not, SGS had the right under the bilateral investment treaty, which I showed you earlier on, to do that. The problem in this case, what happened, the Supreme Court held that the seat of the arbitration being Islamabad, Pakistan, and majority of the contract execution was in Pakistan, was sufficient to determine that the governing law of arbitration is the law of Pakistan and not ICSID rules, as preferred by SGS in a parallel proceeding. Now that is a big issue, because I'll come and explain it in a bit of a second on principles of arbitration further. Law of contract is separate, law of the country is separate, law governing arbitration is separate, law of the seat of arbitration is separate, law of the procedural rules of arbitration is separate. There's quite a lot of laws to understand when arbitration is concerned. Don't panic. It's all under control and it's all in hand. Once you get through this, it will make more sense. But if you want to read more about ICSID, however, just to give you a bit of background, ICSID, this case, SGS, was actually settled between the parties. There is a settlement note which is available on ICSID website as well. Now, Pakistan has now enacted new acts, and the court's view after the enactment of the new Arbitration Enforcement Acts, not the Arbitration Act, these acts are only limited to the enforcement of foreign arbitral awards. So, for example, if there are awards being done in London or in Paris or somewhere else, so they are foreign arbitral awards done internationally. How do you enforce them in Pakistan, and how Pakistani court does not set it aside and actually makes enforcement happen, which is what this law is. So if you look at, there's another case called Global Quality Foods versus Hardee's Food System. Now, in this case, the dispute arose under the multi-unit license agreement and was contended by the defendant that it must be resolved through arbitration under the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. The plaintiff stated, okay, so here they are plaintiff because it's in court, that their operation was covered as an exception of validity under the convention and therefore could not be subjected to the arbitration clause. Again, a bit more technicality and the issues around it. So the courts stated that there was no need to refer the matter for arbitration since the claim did not fall under the ambit of the convention, and therefore the defendant's appeal was rejected since it would lead to no corporal outcome. It's interestingly, in another case, Shamil Bank versus Mia Yazanwar, a suit of recovery of money was filed under the arbitral award, which was pursued in accordance with the arbitration clause between the parties. Now, in this case, the courts held that the statute, Financial Institution Recovery of Finances Ordinance 2011, did not have a provision which allowed implementation of a foreign arbitral award. Again, my problem and the challenge to all of this is the archaic statutes and the laws are not helping commerciality of the parties. So if the parties have agreed to resolve the dispute through arbitration, sitting behind the technicalities that the current law as enforced does not have the relevant, proceedings or clauses to enforce it, is a bit of an issue. However, there has been a lot of law developed under Pakistan Arbitration Act 1940. The high courts, the commercial courts have been very supportive. I've actually had several meetings on this with, Lordship Justice, Honorable Justice Jawad Hassan, and I've also spoken to few others as well on this matter, and their understanding of this matter is really immaculate. They understand how the law operates because they have actually practiced international arbitration as counsels as well. So listening to them and how they interpret and try and support the laws of Pakistan on some of the bad law that was developed previously, I think is really, really important. Justice Jawad Hassan's Pizza Hut case is really important from a foreign arbitral award perspective. And we also need to think about the awards. There is currently an arbitral issue going on with the Porsche case in Pakistan. So I'm following it religiously and closely. So it's important to look into those elements as well. The dispute resolution laws in Pakistan, as I mentioned, we've got the Pakistan Arbitration Act, 1940. This is basically the old English Arbitration Act 1940. Since then, England looked at Arbitration Act 1950. There was then one in 1966. Then the current one is 1996, which is one of the prime examples of how arbitration law is developed, and a lot of countries have literally copy pasted it to develop their own arbitration laws. Pakistan has tried it twice, in 2006. In 2016 was a bit different, followed model law, but different provisions. I'm currently reviewing it. But those elements are important. Pakistan was one of the first signatory of New York Convention 1958. Pakistan was one of the first signatory of Exit Convention 1965. However, signing a convention is not enough. That needs to be converted into law of the country. In 2011, Pakistan enacted law that related to the Exit Convention, so the Arbitration International Investment Disputes Act 2011, and the REACT 2011 is for New York Convention. So both of these laws were enacted at that time. When I say that the 1940 is partially replaced by the ADR Act 2016, actually it doesn't, because it doesn't mention the difference between arbitration, mediation, and conciliation in it. And it just says things about various different elements, but one needs to understand that the current ADR Act 2017, as it is, not 2016, is only enacted in Islamabad, in the capital. Punjab has ADR Act 2019, but there hasn't been an order to enact it. Sindh is also working on its own ADR Act. I know Balochistan and NWFP Khyber Pakhtunkhwa, which is quite high up in ADR provisions, but mainly conciliation rather than arbitration and mediation. And after the enactment, I think you need to look at the case law for Lakra Power, and there is a new case for Orient Power, which was decided by Honorable Justice Aisha Malik, which will provide you with some understanding of the enforcement of foreign arbitral award. And on top of this, as I mentioned previously, Pakistan has several bilateral investment treaties and multilateral investment treaties. Pakistan, China are signatories of a BIT, and any dispute on CPEC, generally the contracts have their own arbitration clauses, how it will be done. Hopefully we don't have any such disputes, but highly unlikely for $100 billion investment that it will come out without disputes. And if they are unable to resolve it within their contractual arbitration mechanisms, parties also have the bilateral investment treaty, so the decision could be sent to investment arbitration proceedings as well, because both the free trade agreement and the BIT elements of Pakistan, China, as an example, allow for that. Okay, so as I mentioned, for foreign direct investment, free trade agreement and the understanding of it is really, really important. Pakistan, China has a free trade agreement. Now, coming back to what does it all mean? The whole perspective of this was to give you a bit of a structure and paradigm into the fundamental principles of arbitration. Now, let's look at how arbitration is conducted and what happens in an arbitration. So the fundamental principles of arbitration, what we are looking at here is, first thing is there really a dispute? If there isn't a dispute, what are we arbitrating for? What is happening between the parties? So the key element that comes in it is the contractual basis. So apart from statutory arbitration, the basis of arbitration is contract. The rights and obligation of the parties to arbitrate their dispute arise from the arbitration agreement they've concluded. Think of it this way. You have an energy contract, and within the energy contract, we are looking at issues around dispensation or provisions of each of the parties. Now, if something is wrong, the party must tell the other party, hey, you've done this wrong. Can you correct it, rectify it, or give me more money so I can do it differently? We can't just initiate an arbitration proceeding for that. The other aspect is, if our matter is related to energy and that's our contract, but now we are trying to dispute on a different matter for a different element, a different entity, different property, for example, for its provisions or its access or anything else, that is not part of this contract. So you cannot arbitrate on that. We can arbitrate ad hoc in terms of creating a new contract that, yes, we've got a dispute, we don't have an arbitration agreement, how about we go to arbitration? Okay, and this is very important, that you are actually allowed to do that. The second, another most important fundamental principle, which is usually found in the arbitration clause or arbitration contract, is seat. The parties usually choose where the arbitration is to take place. So, for example, the arbitration clause says any dispute under this contract shall be decided under arbitration. The seat of the arbitration is London, is Dubai, is Singapore. Why is that important? The seat is important because the law of arbitration or law of the proceeding will be based on where the seat is. So if you then need interim orders, if you then need to challenge the appointment of the arbitrator, if you need to challenge the jurisdiction of the arbitration, it will happen where the seat is. If the seat is London, we can't then start an arbitration challenge on jurisdiction in Pakistan because the courts in Pakistan do not have jurisdiction on the seat in London. If a challenge needs to happen, it will need to happen on the seat. Now, how friendly those courts are for arbitration or for the procedure that follows arbitration is where we need to be in terms of understanding why people choose the seat of arbitration as London or Singapore or Paris or Dubai or Zurich or any other key elements. There is a survey. I would like you to just give a search on it as well. Most preferred arbitration seat. It's a survey done by Queen Mary, University of London, and White and Case. And the reason they do that survey is to define which is the prominent seat. So London has been the most used arbitral seat for the last many years since the records begin, basically. But Singapore is catching up. Singapore is almost neck on neck now. Singapore used to be quite at the bottom. The reason is Singapore enacted new arbitration law that helped the parties through the procedure in the appointment, jurisdiction challenges, powers, duties, seat. The Singapore law is supportive of those elements. There is currently a consultation going on reviewing the Arbitration Act 1996. And I think it will be important for you to think about how to look into those elements as well. Then the next key fundamental principle that comes in is the procedure for arbitration. Now, the parties can choose rules to govern the procedure of arbitration. Okay, this is, for example, LCIA rules or any other rules. So I want to show you this. This is the comparative chart of international arbitration rules. I don't know whether you can still see my screen or not. I hope you can see it. Yes, you can see it. Just checking. So, for example,
Yes, sir, we can.
thank you. If we are looking at Hong Kong International Arbitration Rules, it now tells you how and when the arbitration starts. Default deadline for response 30 days. Okay, default number of arbitrators. So Hong Kong International Arbitration decides it. Compare it with LCIA rules. Okay, sole arbitrator is the standard provision. But then you can think about, do I need two? You can't have two. Do I need three arbitrators or more? One or three is generally the provision. You can look at JAMS rules. You can look at Singapore rules. All of these give you a bit of comparison. So this is a very useful comparative chart and I use it extensively. And I would like you all to think about that as well. Okay. And I've just put it into the link so you can have a look into it. Coming back to our key topic. So procedure is important because procedure defines how everything will be done. The appointment, the parties have the choice. Whatever rules they are choosing, they can amend those as well. That the arbitration will be done by a sole arbitrator. That's just one. Or arbitration will be done by a tribunal, which is 3 arbitrators. Further rules. Each party selects an arbitrator and those 2 arbitrators select the 3rd arbitrator or the chair or the neutral or the umpire, whatever you want to call it. So those are important elements of procedure, how the tribunal is appointed. If parties disagree on the appointment of the tribunal or the sole arbitrator or someone else, Again, we need to look at what the seat, the law of arbitration allows you to do that. So if you look at the English Arbitration Act 1996, you can ask the court from that perspective as well. Same as what happens usually in Pakistan in Arbitration Act 1940. There, we don't have those, like CIAB didn't exist or any other, where you can go to a private organization and say, oh, can I have an arbitrator, please? Pakistan always had that element. We either selected ad hoc from our own connections, where the laws of impartiality and other things generally go in the bin. But we need to think about how that element comes into it. And then the other aspect, which is a very fundamental key point, is the powers of the arbitration tribunal, because the tribunal derives its power from the arbitration agreement. The arbitration agreement, the seat, the contractual basis, and the procedure. That's where the tribunal is getting its powers from. Okay? Because these powers are supplemented by any applicable legislative procedure. And that's why the seat becomes important. Okay? So we need to think about that element of the seat, because that is where the powers and duties of the arbitral tribunal are coming in, because this is where the tribunal has the right to define its own jurisdiction. When it's come to jurisdiction, the arbitral tribunal may decide on its own jurisdiction, but that decision is subject to review by a court at the seat of arbitration. In Singapore, if the tribunal has decided that it has jurisdiction, the law of Singapore doesn't allow the courts to review it. But in England, if the tribunal has decided that it has jurisdiction on that specific dispute, the courts have the power to review that. That's one of the reasons why the parties may choose Singapore over London, because if that's the case, then things are different, because the seat of arbitration determines the law governing the procedure of the arbitration. So if the seat is the judicial seat, that is the country where it's rooted, so Singapore or London, so those the international convention concerning arbitration is the New York Convention, but the law governing the procedure of arbitration is the seat. So it's really important for parties to choose the seat accordingly. Now, if we choose Lahore as the seat of arbitration, we need to then consult the Arbitration Act 1940, which has so many gaps, so many issues, that it probably requires a week of explanation from my side of the issues that are in it. Okay, so we need to look at it from that perspective. So that's kind of the one element. Then we come into the award and challenging the award. One of the key elements of the arbitral award is the finality. Decision on the merits of the dispute by an arbitral tribunal are usually final and not subject to appeal, although the award may, in exceptional circumstances, be set aside by a court at the seat of arbitration, right? At the seat of arbitration. Think of it this way. I'll give an example of the Arbitration Act 1996, because I'm not going towards Arbitration Act 1940 at the moment. So from London's perspective, Section 67, 68, and 69. Okay. 67 is a challenge on jurisdiction, that the arbitral tribunal did not have a jurisdiction, so they have no power to make this award, and hence it needs to be set aside. Okay. Section 68, if there was a procedural impropriety, that there was a breach of natural justice, the procedure was not followed, the rules were not followed, the governing seats procedures were not followed, and the arbitral tribunal did not do what it was supposed to do. So you're not looking at the merits of the award, how the arbitral tribunal has decided, how they have reasoned the award, but you're looking at the procedure. And Section 69 is if there was an error of law. If there was a complete issue on error of law, then of course you've got a problem and you can challenge the award accordingly. Enforcement, again, decisions of an arbitral tribunal are widely enforceable. You can enforce it anywhere who is a signatory to New York Convention. And there are specific requirements, again, from each country. Like if you want to enforce an award in China, how does it deal with it? There are separate procedures for England, France, UAE, and the US. There is a specific provisions for Pakistan. REACT, recognition and enforcement of foreign arbitral award. So that deals with the enforcement issue. And this is where I always say court's powers or judicial intervention, actually it's none of that. It's actually court supervision. And this is a very important and fundamental point, specifically to be discussed in Pakistan, because the courts don't like to intervene in an arbitration, because generally when it's arbitration happening, the courts simply say go and arbitrate. They will only try and supervise, and they are bound by the law that is in the country. So at the moment, the Pakistani courts are bound by the laws of Pakistan, which are governed by the Arbitration Act 1940. I mean, think of some important elements of the court's powers, the role of the court. Pre-arbitration, if you want to take a stay on arbitration or stay on legal proceeding, you will go to the court. You can't do it yourself. If you want to have a witness brought to an arbitration, the arbitral tribunal don't have those powers. They have to go and ask the court to summon that witness to the arbitration. If you have a problem in appointing arbitrators, what do? You go to the court. If you want to extend time limits for commencing arbitral proceeding, what do? You go to the court. During the arbitration, we need to think about if there are any interim orders that need to be. So for example, in a construction contract, somebody wants to cash in a bond. The dispute is in arbitration, going to be decided, but that party goes in to cash in a bond. The arbitral tribunal don't have the power to do that. They will need the court's help. So courts have a very important role to play in arbitrations. And that's why it's fundamental that any ADR procedure that is being implemented or enforced needs to look at the preliminary points of law of that country. And that's why I mentioned and re-emphasized the element of the seat, the procedure. So the law of arbitration and the rules of arbitration, very important. Just last point on court's powers post-award. It's very much the court's powers post-award are in terms of enforcement, hearing any challenges, setting aside the award. If there are some errors, administrative error, that the arbitrator made a mistake in the formula of calculating damages that were requested by the parties, of course they're not challengeable in under any other issue. You can correct the award, but it again depends on whether the provision in the law allow you to do that. And those elements become really important. There are a few things that I would like you to think about and read through. I just want to share it very quickly. Is one of the important element is the United Nations Convention, okay, the New York Convention, which talks about arbitral awards and everything else. I think the articles are very important. So if you want to understand the fundamental principle of arbitration, then you need to read the New York Convention, because this convention clarifies all the elements that are needed from an arbitration perspective. Article 1 explains the terms arbitral award, where, in what capacity. Article 2 talks about the procedure, needs to be in writing, etc., etc. Article 3 talks more about the rules and procedures as laid down within the parties. Article 4 talks about more on recognition and enforcement, that the award should have been duly signed, the copies should have been made through each party, the procedure should have been followed strictly. Article 5 talks more about if you want to challenge or set aside an award, under what grounds can you do that? So those grounds could be very much related to same elements that I mentioned. If it's public policy issue, okay, if the subject matter is not capable of being arbitrated, okay, is it arbitrable or not? Criminal issues are not arbitrable. Bribery, corruption, fraud issues, again of commercial nature, we need to look at it, and this is where the jurisdiction element of the arbitral tribunal comes into being. So we need to look at all such elements, but please go through that. And the last thing I mentioned about UNCITRAL model law, okay, so this is the law which is followed by various different organizations, and sorry, and then again, these are the UNCITRAL arbitration rules. So law is separate from rules. In ad hoc arbitration or institutional arbitration, you can look at which laws you want to review. For example, these are the institutional arbitration rules. If it's ad hoc, generally people will choose the law that they want to choose, and that could be all the way from CIR to various different elements into how we deal with other aspects as well. And on that, I would like to say thank you very much for listening. And if you have any questions, please let me know.
Thank you, Sir Nasir. That was, I would say, a very, very detailed discussion about the principles of arbitration. Moving towards the comments and the questions, Farishna Tawfiq, she has a question that she recently studied a case of Alabama claims arbitration, but she is confused. Like, if we have a ICJ, then why we need arbitrators to settle a dispute? Because in municipal we go for arbitration, and in a case where we are not comfortable with prolonged procedures, which are never ending process of courts. So the question is that why do we need arbitrators?
Why do we need arbitrators? I think that's exactly what we went through. Why do we need arbitrators? Because if you want confidentiality, if you want neutrality of the decision makers of your dispute, you need arbitration, because arbitration is, that element. You, I mean, I'm not familiar specifically, and I can't see the comment in there. Okay, hang on. Now I can see this webinar about arbitration international level. We recently studied a case of Alabama claims arbitration, but I'm very confused. Like, if we have ICJ is International Court of Justice. That's general. Is that correct? So that's for
Yes,
criminal
sir.
issues, not civil issues. You have international commercial courts, for example, DIFC and Singapore International Commercial Court. But again, whether the parties want to choose international commercial courts or arbitration, that's down to the parties. I think the key issue is the Alabama claims were very old. You're talking about something in the 19th century, and arbitration has definitely moved on since then. And the shipping industry is global. Think about it from the shipping and logistics elements. We are moving towards more e-trade and e-financial institutions. So how do we deal with that through a domesticated court other than not going to arbitration? And the reference to ICJ is, I'm sorry, but a bit irrelevant in arbitration, because arbitration is for civil claims, not for criminal matters.
Right. The next question is from Bilal Khan. Although ADR procedures are more efficient and cost effective, do you believe that the lack of adequate procedures, protocols, and flexibility associated with these methods may hinder the fairness of the final decision?
So for that, I think the most important element is to look at the IBA, International Bar Association guidelines on conflict and disclosure. I think for any decision to have fairness and impartiality are the soul of arbitration or mediation or any other ADR procedure. If you're not impartial, the decision is not fair. I'll give an example. I was recently involved with a government organization in Pakistan, and they were in a dispute which went to arbitration, and their arbitrator was their ex general manager who had worked for that organization for 40 years and after retirement now acts as arbitrator. How is that person going to make an impartial decision? So that's where fairness and impartiality needs to kick in. Then the matter comes to cost. I think people need to understand whether they go to a trial that can last in a court for 10-15 years and how much money will be spent on lawyers or waiting for that dispute to be resolved, or they go through arbitration. Generally, the arbitrations that I'm involved in are resolved within 12 months. Okay. And that is because they are multi-million pounds and they are very complex and involve expert advice, expert witness statements from both parties, hearings, etc., etc., but still resolved in 12 months. And generally, the parties accept the decisions made by the arbitral tribunal. Only very few go for challenge in the court of the seat or where the enforcement is about to begin. Hopefully that answers your question.
But thank you, sir. That was for today. The questions are answered, and I guess the presentation was enough that the queries everyone had in their minds, all the answers are from that presentation that you give. Thank you so much, sir. To our audience, it's one of the first seminars or webinars based upon arbitration, and we're looking forward to different webinars on the same topic on the upcoming weekends, inshallah. So stay tuned for that. So Nasir, before closing out, any last comments?
And just generally, please keep reading, keep understanding, keep developing, keep learning. It's really important to review things holistically and subjectively and objectively at the same time. There is a lot of resource available on the internet for free. And one of the things CIAB as a global charity and organization does is provides free student membership. So anybody on this call, I would just say, if you are a student or if you are looking to seek more guidance on ADR, not just arbitration, but also mediation, join CIAB, apply, it's free, and you will hopefully get a lot more information. And thank you, Law Students Council, for having me. It's really a privilege, and I'm really pleased to be sharing my experience with you all.
Yes, it's an honor for the council itself for having you on our platform. So with that, we will move towards the closing of our webinar for today. Thank you, sir, once again. It's an honor having you.
Thank you.
With that, thank you all for joining us today. Inshallah, we will be back with another topic on arbitration soon. Stay tuned for that. Thank you all, and Allah Hafiz.